everybody. I'm Dima Fakhoury with Century 21, a real estate broker. And I'm here with the lovely, talented Maria Sturino from Sturino Walker Legal Firm. And it's lovely to have you here. Today we're going to discuss about legalities around tenants and landlords issues, and just talking about the board, the Landlord Tenant Board, and the Residential Tenancy Act. I'm here with Maria. She's a paralegal. She's been in the industry for a while. I think we said about 15 years or so.
11 years to be exact.
11 years, yeah. So every time I talk to her, you're in courts.
Yeah.
Must be busy for you.
Every day.
Yeah.
Every day. It's a good thing because for so long, courts weren't happening or they took too long to happen. So we're just glad that they're finally somewhat catching up. Let's use that word if we want to. But yes, definitely in court, if not once a day, twice a day. There's two types of dockets. So there's a morning tier and an afternoon. Usually I am in both.
So you're busy. I know at one point, up until maybe about a year and a half ago, the whole process from A to Z in terms of going through the court system, whether it's the tenants initiated or the landlords, it would have taken about a year and a half, 2 years sometimes. Now they've cut it short. I guess they've hired a lot more people because of the demand and a lot of the issues that are happening. There's a lot of investors in the market. So perhaps we could talk about how long it's taking right now. I know I'm in the Durham region. I know right now in Durham, it takes about 6 to 8 months from filing up an application with the LTB and then doing the actual eviction with the sheriff. Is that generally the standard time like throughout Ontario, or does it differ by region?
Yeah, so it used to differ. It's a twofold question. It used to differ because it was based on the court location you would go, you'd file your paperwork with, right? There was a Durham region, there was a Mississauga court, Toronto courts, there's a few in Toronto. October 2023, they changed everything. Everything is completely virtual, and they've created an online portal system now is what they call it. So you can't physically go into any courts or Landlord Tenant Board courts anymore, speak to your representative, file paperwork, speak to an adjudicator. It's all done on that portal and then all done via Zoom. So that's eliminated the difference or the time frame difference from region to region because now it's all of Ontario.
Oh, that's great.
That portal system handles it almost like a whole now. So we see it pretty universal. It's no longer dependent on region per se. It is pretty universal to all of Ontario. And they do differ, okay? So timeframes will differ based on the type of application. What you commonly probably come into contact with is N12s, right? You're selling a tenanted property, you're trying to evict the tenant. That's 99.9% of my realtors. So those types of applications, you're absolutely correct. If you're going to start it from the time you file that application to the court date, essentially, it will be 6 months. Okay, sometimes 5 months, but usually 6 months is the average right now. If we're talking about non-payment of rent, that's different. That will take about 3 to 4 months. So they've been putting priority, thankfully, on non-payment of rents. In my opinion, that's because they saw a lot of landlords lose a lot of money. And likely a lot of landlords have tried to pursue legal action against the board from what I'm hearing. I don't do that personally, but I've heard a lot of my landlords say that's the next step is trying to hold the Landlord Tenant Board accountable for losing.
Rightfully.
Absolutely. 3 to 4 months is the key on the non-payment of rent applications.
Okay. That's shortened quite drastically.
This could be 2 weeks, Dima. When I first started, when you filed an application, it was like 2 weeks, 3 weeks max, you're in court.
Really? And then
people are like, it's better.
And then it went to a year. Now it's down to 3 to 6 months. 4 months. That's not bad at all. Obviously, you can't say the same to the bank to wait that long for the tenant to leave before they can make the mortgage payments and then either sell it or get a new tenant, which sucks. And that's why I'm finding as a landlord myself, there's a lot of advocacy going on between landlords to expedite the process. And they've created a lot of different avenues to make the public more aware of what's actually happening in the industry. So there's different forums, like there's Open Room. Open Room is basically a platform where you go in, and once the court issues an order, the court or the landlord can actually upload that court order to the public so that if if a landlord wants to do their due diligence and see if the tenant has defaulted in the past, they could go and check it out on Open Room and see the actual court order. Another thing is front lobby, where if they default, you can actually report that to the credit bureau. And anytime they default, they could go and report it to the credit bureau, which is good because that also gives awareness and also lets tenants know that, hey, it's going to affect your credit rating and it's not good for you. It's not going to look good on when you go and apply for a new place. So that's a good thing. So we're coming around.
Yeah, absolutely. I have a funny story regarding Open Room actually.
Oh yeah.
It happened about, I'd say 3 months ago. So in 2021, I evicted a tenant. Now, I primarily represent landlords here at our firm. We represented a landlord. We evicted a tenant. He owed like $35,000 in back rent. 2025 hits. I think it was January, just the tail end of 2024. And I got a call from another landlord. And he said, Maria, you don't know me, but I know you. I said, okay, how's that? He said, I looked up my tenant's current name, who was also defaulted on rent, and I saw you evicted this exact tenant from another property, which was this client of mine back in 2021. I need you to do the same for me. It's the same tenant, same issue. He was approaching the same amount, $35,000.
Wow.
It's unfortunate that maybe at that time when my new client was able to have the tenant there, they didn't have these types of open rooms, front lobby, right? So there's no deterrence realistically.
Yeah, no.
There was our legal platform. It's called Canly. So it's our legal database here, but it's very tricky to use. It's not straightforward. And landlords are busy people. You're not going to sit 4 or 5 hours doing legal research trying to find if there's a case against Jim Bob on the internet. So I'm very happy and it seemed to be very effective. Another way that it's really effective, this open room particularly, in negotiations, believe it or not, with the tenant. Because now we can use that in negotiations, right? We've served you a notice, but we don't need to proceed with court. We don't need to get an application filed against you. That way there'll be no record if we can resolve this out of court now.
So these are good public platforms to take advantage of. Having said that, now I know I have a client right now that's in the process of cleaning up their home to sell. Okay. So I did advise them to do the N11. However, I also advise people to do it the right way and hire a paralegal, because if they start and they do an error of any sort, then they have to start over again, and that could just take them backwards a few months, right? So typically it's 2 cases where tenants need to leave, is when they're late in rent or the landlords need to sell their home.
Yeah, and non-payment. I would say that's a big one as well.
Yeah, non-payment, defaulting
Yes.
on their payments, and defaulting, late payments, and selling their home. Can you guide me through the process of what applications need to be done? And again, guys, it's crucial that you hire a paralegal, because if you don't and you do a mistake and there's a hiccup, then you pretty much have to start all over again with the board. And it's not fun. And it's not money.
Unfortunately, you are correct, Dima. So as an example, you serve a notice of eviction. Let's use your clients, for example. Okay, let's say they're looking to sell the property and they've sold the property. That's the key. Okay, so there's something called the N12. I'm sure most realtors are aware of it. That is a notice to let the tenant know in this situation, there's a purchaser, I've sold the property, I've signed an agreement of purchase and sale. Those are key components. And the purchaser requires it for personal use. So you go on the Landlord Tenant Board website, you get that notice. It's very straightforward to find this notice, and it's very straightforward to fill it out. However, service of the notice is important. The termination date that you include on the notice. So it's 60 days. I would say the most common mistake my landlord clients make is they give the tenant 60 days, but from when they served the notice. If you read the fine print, it's 60 days to the end of term, meaning assuming it's a month-to-month tenancy, the end of the month is the end of each term. So it can't be, let's say we serve it today, it can't be 60 days from today. It would have to be 60 days from today plus to the end of that term. So February to March to April, it would have to be April 30th. Can't be April 19th. So that's the most common mistake.
Okay.
But you don't know that, right? You just fill it out, termination date 60 days. Unfortunately, it's very particular at the board with these rules. If you think about civil lawsuits, other things, right, you can always amend a statement of claim. If you've made something wrong, you can make an amendment, reserve it. You can't do that at the tribunal. You can file it, think you've done everything right, waiting on a court date. 6 months down the road, we get to court. The adjudicator looks at that notice. If that termination date is wrong, sorry, I can't even listen to you. I know you have a closing date in 10 days. They do not have the jurisdiction to oversee errors on notices, and they have to dismiss your application. You're starting all over again.
And that's why it's crucial to consult with a paralegal.
Yeah.
For sure. Now, the N12 is usually given after an offer is accepted and firmed up.
After an APS is signed.
So an agreement of purchase of sale is accepted and firmed up. Now, before that, typically what I advise clients to do is to try to have the property vacant before they put it on the market, because a lot of buyers, from my experience, I've been doing this for 15 years, I know a lot of buyers shy away from tenanted properties because of the liabilities that come with that. I typically would like to, if my clients can afford to keep the rent vacant for a few months, and I tell them, hey, and if the tenants are on month to month, I say issue them an 11 and just end the term, terminate the lease. Once they're gone, then we could put it up on the market. So for example, I have a property coming up for sale in Toronto, and it was listed with another realtor for a good 9 months. And it was a rooming board. Basically, they had 8 roommates in the house and nobody came in. No showings, no offers, nothing. And it was a prime location in downtown Toronto. And so she called me up through a referral and said, what can I do? I said, you need to get rid of your tenants in a nice way, obviously, and leave it vacant, and then I'm sure it will sell. So we've been through the process. We've gotten the tenants out, and now it's vacant, and we're doing a little bit of cosmetic touch-ups, and it's going to go on the market next week, and I'm sure we're going to sell it at a good price. However, having said that, there comes ramifications with evicting tenants if it's done for the wrong reason. If the eviction is done for the wrong reason, there could be fines. I know right now, if it's an individual landlord, if the fine is up to $50,000, if it's a corporation, it's up to $250,000 for wrongful evictions. I know the laws are changing. Maybe you could emphasize on that as of June. Things are going to be different.
Beyond this, there's other changes. It passed what we call Royal Assent June 2023, called Bill 97. So there's other things, but particularly to your question here, one of the changes that will affect these bad faith evictions are the fines. Okay, and these are administrative fines. These are not fines that go in the opposing party's pocket. It's what the board will impose. Okay, so basically, like when you get a traffic ticket, there's a fine, it gets paid to the court. In this case, it gets paid to the tribunal. So right now you're correct, it's $50,000 for individually owned, $250,000 for corporate. They are doubling that with Bill 97.
Wow.
So $100,000 for individual, $500,000 for corporate.
That's a lot.
Thankfully, they haven't released a date when they're actually going to take to it. So that's a TBD. I'll keep an eye out, and I will let you know, Dima, as soon as I get that information. I'll certainly circulate that. But as of right now, that's what Bill 97, amongst others, that's what Bill 97 is going to, for bad faith eviction fines. I had a question about your N11 because I'm intrigued about the situation. Did the tenants voluntarily agree to sign the N11, or was there something?
That's the thing. No, they have to voluntarily agree to terminating the lease, which they have in this case.
Great. Good for you.
And,
it doesn't always happen.
No, it doesn't always happen. And sometimes we need to give cash for keys, which the listing that's coming up in Toronto next week, the owner, because the previous realtor had promised the tenants to give them 3 months of rent, each person. So 3 times 8, it's a lot of money, right? So my client had to dish out that kind of money to get rid of them.
Okay.
And they did. They ended up leaving, and they were very good about it. But yeah, no, cash for keys is a real thing. But luckily, in my case, with these different clients, the tenants did sign the N11.
That's great. I have one this week. The client just same thing, similar to yours, right? We just want to be able to get the property back before. We're not saying we've sold it. We're not saying a family member's moving in, right? Be very clear and concise. That's what I always tell my realtors. Because then even if you say it, like, oh, we've sold the property, we need you to leave, but you haven't necessarily sold it yet, your intention or your client's intention may be to do. But if you haven't sold it, do not bring that up.
No.
Because I've had situations where unfortunately real estate agents may have said the wrong thing or painted the wrong picture, and then they don't actually sell the property. So the tenants left, even on verbal advisor, not necessarily getting an N11 that was false, just an email from the realtor. Yeah, we sold it, we need the property. And then they didn't sell it. They fix it up, they put it back on the market for double the rent, and who's liable? The landlord client.
Of course.
And oftentimes the realtor gets dragged in that as well because they're the direct party that has made this allegation and brought that forward. So now the realtor is getting dragged into tribunal proceedings as well.
Yeah, no, in this case, my clients are serious about selling because they already bought a property already and they can't keep two places.
Yeah.
So that's their genuine intentions. Yeah. There's a lot of laws, like a lot of investors going in, they need to know. And unfortunately, it is a one-sided law that is in favor of tenants. And people need to do that and weigh out the risk. For the past 10 years, for example, properties appreciated by 117%, which is good. So people have to weigh out the risk of, should we go into an investment property? Should we buy into this? And take the risk and maybe bank on appreciation. There might be losses. There's always, where there's a risk, there's loss, right? But it is a one-sided law though, unfortunately, and hopefully that becomes eventually fair for both landlords and tenants. But why is it that it's one-sided?
The government, of course. Tenants complain, they go down to City Hall. Unfortunately, a lot of my landlord clients just don't have the time. They don't have the capacity to stay out there and with their signs and beg the government for changes. In my opinion, listen, I don't disagree with a lot of the laws. At the end of the day, don't lie to me. If you have to vacate, if I have to vacate because you want the property back, that should just be it. Right, that's the problem here in Ontario. It's not that way. The rent control rule is unfortunately completely unfair. 2.5% was this year's annual increase allowance. Same like last year. There was obviously a memorandum on evictions during COVID too, and then they didn't do an increase for one of the years, 2021. If you think about a 2.5% increase compared to what owners have to face in yearly increases, property taxes, insurance, it's not fair. So I think the government has really made a mistake there by not considering inflation, property taxes, like what, let's make
interest rates
resemble, let's make it resemble the rate that the landlord can increase. Let's make it resemble what these actual owners are facing.
Exactly.
Not a consumer profile index, whatever they call that, the institution that comes up with it. It's totally off. Another thing, I think that varies, and I have my partner's from Chicago, so he's from the States. Very different laws there, and I always compare the two. We're neighbors, so I like to think that for the most part we have similar things, ways of lives and cost of living. In Chicago particularly, that's all I can speak to. I'm assuming it's the same everywhere, but in Chicago particularly, at the end of your lease term, so let's say I've signed a 1-year lease with you. At the end of the lease term, I as a landlord can decide, okay, we will renew another lease, 1 year, 2 year, whatever term, or at the rate of X, right? So we can agree on an amount. There's no rent control. The government doesn't come in and say you can only increase the tenant's rent after the term X amount of dollars. At the end of the day, that contract is complete. Let's look at it as a contractual agreement. You fulfilled it by providing me the property. I fulfilled it by staying here a year and paying you the monthly rent. We renegotiate a new contract. Not that I get to continue living there after the lease is done and you're only allowed to increase 2.5%. I think that is the biggest shift. If that were to shift, I think that would be a lot of the problem solved here in Ontario.
Oh, absolutely.
I may take a loss for the year. Maybe I went too low in my rent, right? And next year I know it's going to cost $3,500 to run the rental property. But now I can reflect that to the tenant. If they don't want to stay, I'll find someone who will be able to afford that,
Mhm.
and they're not at a loss. Yeah, I'm not desperate. I'm not trying to find all these loopholes in the system and say I'm going to be moving in or my son's going to be moving in and then they don't. This is where the bad faith evictions come into play.
Mhm. Mhm.
At the end of the day, the board's, oh, it's not, it's a property, it's a home. But to the same tune, it's a landlord's investment.
It is.
It's a numbers game.
And there are, a lot of times there's small investors that are just
Yes.
trying to make some money and
Yeah.
make a living out of this.
That's right. Retirement. I have a lot of clients that it's their retirement.
Mm-hmm.
And then they end up losing. Tenants are staying there for 12, 13, 14, 15 months without paying.
Mm-hmm.
And now you have an 85-year-old man on a pension trying to juggle his own expenses for his own property plus the rental property.
Right.
Sad. It's a very sad situation.
Sad.
That way.
And it's not like that in other provinces in Canada. Alberta's rate is much more fair, and it's just here in Ontario. To me, I have a feeling, or I don't know. I feel like the public want, or the government wants to avoid homelessness by throwing it onto the private sector. Pretty much.
Perfectly put. Perfectly put.
Because if these people, if landlords were able to evict these people within a month, these people are going to end up homeless, and it's going to be on the government's burden to take care of them and find them shelters and places and food and all that stuff, right? So they're putting that onto us, the private sector, which is not just. We have to pay our bills too, right? And mortgages and that. Yeah.
And I think supply would go up, to be honest, if the laws changed.
Oh, absolutely.
I have so many landlords, after we go through this whole eviction process, they're like, Maria, I'm keeping the unit empty. I'll pay my vacant home tax. I don't mind. I don't want to take this risk anymore. I don't want to bear this burden. I don't want to have to go to the tribunal again and go through a year's process.
It's very stressful to go through to the tribunal. It's really stressful.
Yep.
Again, who needs that extra emotional stress? Life is stressful as it is, right? Yeah. Yeah. Okay, can you tell me about other delays that potentially could happen from the court side? I know it's systemized, but obviously there's delays, and that's why we're seeing a long waiting time before tenants are out of the property.
Certainly. So there could be two delays. So I'm talking, we already spoke about the N12. The N12, there's a termination date. If the tenant decides to challenge the notice, they have the right to do so, unfortunately, and that's when we need the board's intervention. So we file the application. It could, let's talk like we did previously, it could take 6 months for that court date. 6 months is to the court date though. So unfortunately, once you get to court, obviously again, because I represent landlords, our client's position is we need the fastest eviction. So it's called a standard order. That's the legal term. The fastest the board at the court date can terminate the tenancy is 11 days. To be very frank with you, very unlikely.
Can you tell me circumstances which this falls under?
Certainly. So the tenant is still able to say, so let's say the landlord is able to prove, I've sold the property, here's the APS, declaration from the purchaser, they're verifying they're going to be moving in. The board still needs to consider the tenant's circumstances. Do you need more time, tenant? And if so, why? So examples that would lead the board to extend the termination date for the tenant is things like physical disabilities. So I'm not your average person. I have maybe issues physically, broken back, I don't know, an amputated arm, things again of physical disability that would restrict their ability to move out that fast. Health situations, right? So maybe some people are ill, going through cancer, have conditions that require additional assistance for the move. And the biggest one is children. Okay. Most of the time, if individuals are within a school district, they may say, we won't be able to afford staying in this neighborhood. We've looked, here's our proof, here are comparables. We know we need to move out of the district if we get evicted. My child is in school right now. I would like for them to finish their school year, June, and then we will be able to move and have an easy transition into another school district for the child. Doesn't always happen. Okay, because our position is it's likely that you didn't just get notified of this. You knew about this 6 months, maybe potentially 8, 10, 12 months before. So what have you done to prepare this as a possibility? 99% of the time, tenants can't answer that question.
Okay. That's true.
They've just been waiting on the court date and they've read it forms and they know. Okay. Or sometimes they actually have looked, right? Some tenants may be able to demonstrate that I've applied, here's a situation. And then at that point, it's going to be at the adjudicator's discretion to decide. Okay, who's more prejudiced? The landlord who has a closing date in a month and could potentially face fines if they can't close and provide vacant possession to this purchaser. If the purchaser can also demonstrate that they may be homeless, that's a factor that the board needs to consider as well, because they may be buying this home, selling their home that they're in, and now they're on the street. So unfortunately, it's case by case, of course, and then it's at the adjudicator's discretion. I would say typically it's 30 days right now. If we're talking about an average case, maybe there's no, circumstances that the tenant can really rely on. It's approximately 30 days. And why I say that is because, let's say best case scenario, we get the standard order. The adjudicator will take about 2 to 3 weeks to actually write their order. As of right now, there's probably 10, 12, 20 cases on a docket, right? So when you go to court, you're not the only one being heard at, let's say, that 9 a.m. There's 20 other cases with you that day. So the adjudicator needs to make sure they're able to go through 20 cases in a 3-hour span. As opposed to giving an oral decision, which would take time and consideration, they what we call reserve their decision. I hear your case, great, I'll think about it. I will issue on an order in the coming weeks. Right now, it's about 2 to 3 weeks. That's the average. However, if we read the legislation, it says the Landlord Tenant Board allows their adjudicators to take up to 60 days to issue the order. During that time, the tenant gets to continue living there.
Yeah, it's funny you say that. I remember just last year, there was the owner had to move back into the property. And after he left his own property, I think he sold his home and thinking that he's going to move into his tenanted property. And that wasn't the case. He ended up sleeping on his boat on the driveway of his rented property until
on the driveway.
Actually on the driveway in his boat until the tenants. That was a few months. It is definitely one-sided, and I think it needs to be.
And then beyond that, unfortunately, the tenants can still challenge the notice. Let's say they don't agree with the adjudicator's decision. They have the right to challenge it. Of course, they have to have legal merit, right? Errors in facts, but they are still able to challenge it. And if an adjudicator reviews it and says, okay, and maybe this is grounds for review, that halts the state, it halts the eviction, regardless of the date that first adjudicator gave to you. And then you have to wait another 1, 2, 3 months for another court date. Have that matter heard, maybe reheard again, depending on the issue that the tenant brings up with the order.
And then the sheriff, by the time the sheriff comes, some municipalities, it takes weeks, sometimes a couple of months. So that prolongs things even more.
Yeah. So that's why I really tell my clients when they're like, oh, cash for keys, we don't want to pay out the tenant. They are only entitled to 1 month's rent. Absolutely. But you as a seller, you have to, it's a cash register deal. Right? You have to give your tenants more money than they're entitled to. Sometimes it's outrageous, the numbers that we see. You have to think about what could this do to the sale of the property.
Oh, absolutely.
Money, right?
And I always say to my landlord clients too, to empathize with the tenants, because at the end of the day, they're trying to live too. It's good that it's nice to be compassionate with them and maybe help them out, maybe help them find a different place to live in. Like
a lot of tenants are living month to month.
So they truly, generally can't afford to leave that place. And
first and last.
It's a kind thing. Yeah, it's a nice thing to do, to be able to help them and maybe take on the costs of moving and all that's needed to get them out of the place for legitimate reasons, like if you're moving back into the home, or you want to really sell it, or want to do major renovations or whatnot. Yeah.
And I'm with you on that. And I'm glad you brought that up, because I think during this process, because landlords know it's an excruciating process, tenant knows as well, like the tenant knows as well, right? I could be facing eviction. I have a child. Maybe they've been there for 10, 20 years. That's really been their home.
Yeah, for sure.
Sometimes we forget we're all humans. Right?
Yes, at the end of the day, we're all humans,
Like you said, show a little compassion. It can go a long way.
Absolutely.
And in my experience, it does. Landlords are putting the property up for sale. Some landlords are like, no, I'm just putting it for sale sign. I'm not letting the tenant know. It's just common courtesy, right? If
No,
you
it is absolutely, it is.
them on board, they're not going to be, they may be upset in the moment, but I think they'll appreciate the fact that you're keeping them in the loop.
Yeah, and on the other hand, too, I see some landlords that are so attached to their properties that they are invading the tenant's privacy. I've heard of stories where landlords actually peek through the windows to see who's living in their house other than the people that are actually on the lease. And that's invading people's and families' privacy. Who wants to see someone creeping up on their window, right? So it happens, right? Yes, yeah.
Some of my landlord's clients, unfortunately, they sit outside, they're taking photos.
Oh, yeah.
That's a no. So
Yeah,
no. I always tell my clients, would you like that if that was happening at your home? Like,
Exactly.
that's the looking.
Exactly. Okay, a lot of times landlords are owed, let's say $40,000, $50,000 in rent arrears. What happens in that case? Can they actually go after the tenants and claim this through collections?
Yes. So there's a couple avenues. I'm going to talk about the legal avenue, of course, because that's the only thing our firm does. Now, in terms of the maximum rental arrears that the board will award you, sometimes, unfortunately, the tenant does default and they're over $40,000, $50,000. The Landlord Tenant Board mirrors the maximum in terms of jurisdiction maximum to what the small claims court does, $35,000. So in a situation where your tenant owes you above $35,000, the adjudicator at court will ask you, are you willing to waive the remaining? Let's say it's 40 they owe you. Are you willing to waive the 5,000 in order to keep it in this court jurisdiction? The simplest answer, if it's that close to the maximum, I always say yes. Because the eviction, yes.
So,
the eviction,
I'm sorry. So just to clarify, so the jurisdiction offers the landlord up to $30,000. That's the cap, and then anything on top, $35,000. Anything on top of that, they'd either the landlords have to waive that and forgive, or they'd have to go through collections, either through small courts or go after their judgments, basically. Judgments, right?
Assuming that's the case, it's under the 35 or 35 and under, you get an order from the tribunal, the Landlord Tenant Board. The order will not only enforce an eviction, so say by this date, but they'll also say you owe the landlord to this date X amount of dollars. If you have that order, you can then take it to the small claims court. Small claims court will do what we call an over-the-counter judgment for you. So typical small claims court process, just to make it fast, you have to go to small claims court, you fill out a plaintiff's claim, you have to serve it to the other party, they have 20 days to respond, then there's a settlement conference. If the defendant has responded, you bypass all of that if you have an order from the Landlord Tenant Board and you're willing to get a judgment dollar for dollar. You can't start adding things. Oh, but they broke a window and they removed a door. You can't. The small claims will say, if you're willing to take this order and get a judgment dollar for dollar, we will issue that to you over the counter. Okay, so almost immediately. And then from there, with the small claims court, there's what we call enforcement options. So basically collections, and that's legal avenue. So the most popular with tenants is garnishments of a bank account. You know the bank account number, the institution they bank out. I think that's typical on a rental application. When the realtors get involved, you guys do ask them to fill that information out. So if you have that from the commencement of the tenancy, you can garnish a bank account. Of their institution, the financial institution, they will put essentially a lien on it, and whatever funds are in the account, up until to satisfy that judgment you have, it will be issued to you. Okay? Or a garnishment of a wage. You have to know where the tenant works, and garnish the employee, and then they can only take a percentage of your wage, but until the debt is cleared, that employer must pay you to satisfy the judgment. What we call a writ of seizure and sale. Not typical, because the tenant has to own real property, a car, a boat, a cottage, something where you can actually put either a lien or seize it if it's the value of the judgment. Those are the legal avenues of the small claims court. Beyond that, you can certainly get a collection agency involved, okay? They probably take a percentage from my understanding, but that's outside, let's call it the legal realm in terms of what the enforcement through the small claims court would be. What we do here is the small claims court collection.
Right. Interesting. What if they're on ODSP or social assistance of some sort?
Can't garnish that.
Can't do anything about that, right?
Can't garnish CPP either, unfortunately.
Mhm.
So
Yeah. So,
yeah, those are protected incomes.
yeah. But you still are allowed to get compensation through the tribunal of up to $35,000.
You'll get the
Okay.
order from the tribunal with that, and then it's
Mhm.
up to you how you want to pursue it. That's the misconception too. That's a good point. Oh, I got an order against them. That doesn't mean they have to pay you.
No, absolutely
They'll
not.
find the money. You still
Yeah,
got
you have to go look for it. Yeah,
Yeah.
absolutely, absolutely. Yeah, it definitely renting out properties is not risk-free. There's a lot of risk, lots of headaches.
Mhm.
Now, again, it's up to the landlord whether they want to take it on and bank on. I don't want to say cash flow right now. There's no cash flow really unless they put in a big amount of down payment, but mostly bank on appreciation. So they have to weigh the pros and cons and see if it's worth it for them. Yeah.
Very different. My parents, when they came to Canada, that was the play, right? We buy property, rent it out, eventually give it to the kids or sell it.
Exactly. Yeah.
To the kids. And it was a handshake. My grandparents, they're still landlords. They still have a tenant in their basement.
Yeah.
That was generate more income for them, but it's very different. And thankfully, they've been blessed with great tenants. One tenant was there until he passed away.
Wow.
So plus
That's
years.
amazing.
Yeah, so they
Part of the family. Yeah.
Yeah. He was part of the furniture, absolutely. I was always concerned being in this industry. I said, God forbid something happens.
Yeah.
The tenant unfortunately takes their position, or the tenant feels like their obligations or their rights are not being fulfilled. Because I'm going to be honest, my grandparents, 80, 85, are not necessarily very versed in the law. No removal, for example.
Right.
The tenant just always removed it for them because my grandparents are older and it was always a younger tenant. I had to turn to them and say, no, that's what we call them, grandpa and grandma. You have to remove the snow by law.
Yeah.
If you stopped shoveling, you got to do it. So that was just completely foreign to them. Right?
Yeah. The laws are always evolving and changing, right? So I don't blame them for not knowing. Yeah. Yeah. One last thing I wanted to bring out is if the landlord is actually sharing common elements with their tenants, and it does not fall under the Landlord and Tenant Board or the Residential Tenancy Act, right? If they're sharing the kitchen, the bathrooms, whatever, then that doesn't fall under the act, and there's different repercussions and ramifications that to take if they want to
procedure altogether.
Yeah,
absolutely.
Totally different procedure to get them out if they wanted to.
You are correct. And
which is much easier than
yes, I would agree. Sometimes depends on, because usually police enforcement, right? That's at the end of the day. You're giving your notice, you're supposed to leave. You're now what we call a trespasser to land.
Yeah, that's why I say there's different ramifications to that. So it's not, but yeah.
In addition to landlords sharing that space, it's also the landlord's child or spouse.
Yeah, for sure.
So if your son owns, I put my son in the rental property and he has roommates, they're not tenants. They live with my son. Same thing. They're exempt from
the law. Yeah, and the same thing goes to evicting tenants or terminating the lease because the landlord wants to move in. It also applies to their immediate families.
Correct. That is correct.
Yeah. Good. Excellent.
Awesome.
Thank you so much. I think we talked a lot about a lot of different things. It was really nice talking to you and having these discussions. I think we need to have more of these discussions. People need to be more aware, especially if they want to get into investments.
Yes.
And no, I appreciate all your information. Guys, if you need a paralegal that will do their job and do it right from the get-go, please give Maria a call. I will put your information below in the comments. And yeah.
Thank you so much. It's been a pleasure.
No problem. Thank you.